Good day, I am Jake Rañada from BSHM 3A, and this time I will be tackle the chapter 5, which is about law on sales, agency, and credit transaction. What are the learning objectives? First, describe and explain the nature of sales transaction. Second, identify the functions and operations of agencies in the industry. And lastly, identify ways of handling credit transactions. Law on sales. In the tourism, travel, and hospitality industry, agreements arising from contracts will be or have to be made, and potential breach from these agreements will be encountered. A contract of sale is one of the usual contracts being encountered by the industry concerned. This will give you an overview of the different sales transactions which may be encountered, including the remedies of the parties concerned. In the law, in Article number 1458, by the contract of sale, one of the contracting parties obligates himself to transfer ownership of and to deliver determinate thing, another to pay therefore a price certain in money or its equivalent. A contract of sale may be absolute or conditional. Characteristics of a contract of sale. First, consensual. A contract of sale is perfected by mere consent. No form is prescribed for the perfection in a contract of sale, except in the following instances. First instances is those covered under the statutes of frauds which must appear in writing, otherwise the sale is considered unenforceable. Second instances is the sale of real property made through an agent, in which case the agent's authority must be in writing, otherwise the agency and sale made through an agent is void. Second characteristic of a contract of sale is bilateral, because it gives rise to reciprocal obligation. Next, principal, because it can stand by itself without need of another contract. Next, one ruse, because the consideration of each party is the delivery of the thing or the payment of the price. Next, commutative, because what the vendor or the seller delivers is considered equivalent of the price paid by the vendee or the buyer. Next, nominate, because it has a designated name under the Civil Code of the Philippines, which is sale. And lastly, transmissive of ownership, because the vendor transfers ownership of the subject matter in the vendee or to the vendee. Requisites of a contract of sale. Consent. Consent is manifested at the meeting of the offer, which must be certain, and the acceptance, which must be absolute, upon the thing and the cost which are to constitute the contract. The following are disqualified to enter into a contract. First, husband and wife. A sale between husband and wife in violation of Article number 1490 is inexistent and void from the beginning because such contract is expressly prohibited by law. Second, disqualification to enter into a contract is the following persons cannot acquire by purchase even at public auction or judicial auction, either in person or through the mediation of another. These persons are first the guardian, the property of the person or persons who may be under his guardianship. Next, the agents, the property whose administration or sale may have been entrusted to them, unless the consent of the principal has been given. Next, the executors and administrators, the property of the estate under administration. Next, public officers and employees, the property of the state or any of the subdivision thereof, or of any government-owned or controlled corporation or institution, the administration of which has been entrusted to them. Next, justices, judges or prosecuting attorneys, clerks of superior and inferior courts, and other officers and employees connected with the administration of justice. The property and rights in litigation are levied upon on execution before the court within those or whose jurisdiction or territory they exercise their respective function. And lastly, any others especially disqualified by law. Contracts entered in violation of above shall render the contracts void by reason of public policy, and because such contracts are also expressly prohibited by law. Effect of loss of the object in a contract of sale. In Article number 1480, any injury to or benefit from the thing sold after the contract has been perfected, from the moment of the perfection of the contract to the time of delivery, shall be governed by Article number 1262. In Article number 1262, an obligation which consists in the delivery of a determinate thing shall be extinguished if it should be lost or destroyed without the fault of the debtor, and before he has incurred in delay. In Article number 1496, the ownership of the thing sold is acquired by the vendee from the moment it is delivered to him in any manner of the ways specified in Article number 1497 to Article number 1501, or any other manner signifying an agreement that the possession is transferred from the vendor to the vendee. For the discussion of this law, first, if the thing is lost before perfection of the contract is considered inexistent. Therefore, the loss is borne by the seller based on the principle of res spirit domino, or it is the owner of the thing who bears the consequences of the loss. Second, if the thing is lost at the time of the perfection of the contract shall be considered without any effect. The legal effect is the same as the object is lost before perfection of the contract of sale. Third, if the thing is lost after delivery, the buyer bears the risk of loss since delivery transfer ownership, the following the principle of respirate domino. And lastly, if the thing is lost after perfection but before delivery, the seller bears the risk of loss since there is no delivery yet. Hence, no transfer of ownership to the buyer. This is considered just and equitable, being more in conformity with the principles of res spirit domino. In this case, the buyer may demand the return of the price, in case payment has been made. The reciprocal nature of a contract of sale dictates that when there is an obligation to deliver a determinate object, there is also an correlative obligation to pay the price. Therefore, once the obligation to the deliverer is extinguished, the correlative obligation to pay the price is also extinguished. This rule will apply even if the thing is lost through fortuitous event or even without the fault of the debtor. Sale of personal property payable in installments. It is possible that in buying personal properties used for public transportation or delivery of goods, this provision will be useful for the contracting parties in case of sale of personal properties payable in installments. In Article number 1484, in a contract of sale of personal property, the price of which is payable in installments, the vendor may exercise any of the following remedies. First, exact fulfillment of the obligation should the vendee fail to pay. Second, cancel the sale. Should the vendee's failure to pay cover two or more installments. And lastly, foreclose the chattel mortgage on the thing sold. If one has been constituted, should the vendee's failure to pay cover two or more installments. In this case, he shall have no further actions against the purchasers to recover any unpaid balance of the price. Any agreements to the contrary shall be void. For the discussion of this law, in order for the above provisions To apply, the following requisites must occur. First, contract must be of sale. Absolute sale, not a contract to sale or a contract of loan or a pack to the retro transaction where redemption is effected in installments. Second, what is sold is personal property, not real property. And lastly, the sale must be on an installment plan. It must contain at least 3 installments. If the sale is for cash or on straight terms, hereafter and initial payments, the balance is paid in its totality at the same specified. In Article 1484 does not apply. Double sale. Caution should be practiced by real estate developers engaging in the hotel industry, especially on real property located in potential yet unexplored provinces. The principles on double sale will be useful in case an issue on a sale of a real property to different vendors shall be brought before the courts of law. In Article number 1544, if the same thing should have been sold to different vendors, the ownership shall be transferred to the person who may have first taken possession in good faith, if it is should be movable property. Should it be immovable property, the ownership the ownership shall belongs to the person acquiring it who in good faith first recorded it in the registry of property. Should there be no inscription, the ownership shall pertain to the person who in good faith was first in the possession, and in the absence thereof, to the person who presents the oldest title, provided there in good faith. For the discussion of this law, the above provision pertains to the same property which has been sold to different buyers or vendees. In case an immovable property covered under the Torrens title is sold to different vendees, the one who is the first registrant in good faith at the registry of deeds where the property is located shall be preferred. Obligation of the vendor. In Article number 1495, the vendor is bound to transfer the ownership of and deliver, as well as the warrant, the thing which is the object of the sale. In Article number 1496, the ownership of the thing sold is acquired by the vendee from the moment it is delivered to him. In Article number 1497, the thing sold shall be understood and delivered when it is placed in the control and possessions of the vendee. For the discussion of this law, under the above provisions, the obligations of the vendor are: first, to deliver the thing; second, to transfer the ownership of the thing; and lastly, to warrant against eviction and against hidden defects. Obligations of the vendee. Article number 1582. The vendee is bound to accept delivery and pay the price of the thing sold at the same time and place stipulated in the contract. Actions for breach of contract of sale. There are two types of remedies. First is the extrajudicial remedies, and the second one is the judicial remedies. For the extrajudicial remedies, there are two types. First is the of the buyer, the second one is the of the seller. For the of the buyer need not pay unless there is delivery. Second, the buyer may reject improper deliveries. Lastly, the buyer may suspend payment if he is disturbed in the possession of or ownership of the thing or has reasonable grounds to fear such disturbance. For the of the seller, vendor is not bound to deliver the thing sold if the vendee has not paid the price. Second, installment sales or recto and maceda law. For the judicial remedies, there are also two types. First is the of the buyer, second one is the of the seller. For the of the buyer, damages for breach of contract. For the of the seller, recovery of the price and damages in case of bad faith. Law on agency. The hotel, tourism, and hospitality industry cannot do away with agencies which will facilitate various transactions and dealing with third persons. Hence, there is a need to understand the operation of agencies working on behalf of the principal belonging to the hotel, tourism, and hospitality industry. In Article number 1868, by the contract of agency, a person binds himself to render some service or to do something in representation or on behalf of another, with the consent or authority of the latter. For the discussion of this law, a contract of agency is a relation in which one person, the agent, acts on behalf of another which the authority of the latter. The principle, it is a fiduciary relation which results from the manifestation of consent by one person that another shall act on the performer's behalf and subject to his control. With consent by the other so to act, the acts of the agent will be binding on his principal. The essential elements of agency are: first, there is consent expressed or implied. Second, the object is the execution of a juridical act in relation to a third person. Third, the agent acts as a representative and not for himself. And lastly, the agent acts within the scope of his authority. An agency is distinguished from the lease of work or services in that the basis of agency is representation, while in the lease of work or services, such as architect, construction building, worker, painter, physician, processor, employees, and house helpers, the basis is employment. Law on credit transactions. Companies in the tourism industry are likely to face debts. That is why it is important to know the different ways in handling debts in relation to third persons, as well as credit transactions emanating within their respective companies. In Article number 1933, by a contract of loan, one of the parties delivers to another either something not consumable so that the latter may use the same for a certain time and return it, in which case the contract is called a comodatum, or money or other consumable thing, upon the condition that the same amount of the same kind and quality shall be paid, in which case the contract is simply called loan or mutum. Comodatum is essentially gratuitous. Simple loan may be gratuitous or which stipulation to pay interest. For the discussion of this law, comodatum is a loan for use wherein the property land must be returned. Comodatum is essentially gratuitous. For example, when Mr. Smith, a visiting tourist, borrowed the house of Mr. Magno, and Mr. Smith was allowed its free use. Dr. Magno became a bailor in comodatum, and Mr. Smith is the bail. Simple loan or mutum is simply the delivery of sum of money to another under a contract to return at some future time an equivalent amount with or without additional sum. It is a transaction wherein the owner of the property, called the lender, allows another party, the borrower, to use the property. The borrower customarily promises to return the property after a specified period with payment for its use, called interest. The documentation of the promise is called a promissory note when the property is cash. The credit of an individual means his ability to borrow money by virtue of the confidence and trust reposed by a lender that he will pay that what he may promise. The concession of a credit necessarily involves the granting of loans up to the limit of the amount fixed in the credit. That would be all for that discussion. Thank you so much.